Red line dreams we unfold. Engine roar when we hit your town.
Hang on just a second. Get some fix here.
No gas, no brakes, little.
All right. Hope you're doing okay today. Yes, I did actually forget to put it on there. I talked about it, but I didn't. But I forgot to put it out there. But it doesn't matter.
Oh well, that's okay.
Yeah, it's okay. Yeah, let me get this Bluetooth off of here so it doesn't keep trying to go over there. You know, I forgot why I hate this. This lipstick. I'll leave it up here. I thought, oh shit, I don't have any. So I went over there and grabbed it. It's like, oh god, that's why it's up here. It's gross. Anyway, let me get this turned off over here. Because what happens is my Bluetooth will keep trying to connect over here instead of staying over here. I mean, what?
Oh, okay.
All right, I guess we're ready. So, anyway, I hope you had a wonderful afternoon yesterday.
Yeah, I just worked. Yeah, it was just work. I worked yesterday, so. Yeah, yesterday was my Friday, so.
Okay. Yeah, it's just gross.
And then night before that, he came over for a little bit, so. He didn't make it too late of a night, thank God.
That's nice. I'm glad he did. I'm glad you had a visit. That's nice.
Yeah.
I feel like everything's in the way. I'm not ready. Anyway. Yeah, I just feel like there's shit all over me now. I hate this. Okay, anyway. We'll get ready to go. So, you know, yesterday we did Madison McDonald, and she's the lady in Texas who decided that she would just, to protect her children from further abuse, she would just take their life. That way they would be spared. You know, so she thinks that in her craziness that her family is abusing her children, and so sexually, etc. So this way, they can't be abused anymore. But CPS, again, had been involved already, as usual. It's always the same, isn't it? CPS is involved in these cases when these kids go missing, dead, whatever. So I was like, oh, God. And the husband, she has two different baby daddies. One of the baby daddies, of course, well, she had bipolar and she had this and she had that. But I never thought she would take the kids' lives. I mean, but you knew she was mentally ill and you had children with her anyway.
Yeah, and you left the children there.
Well, actually,
why risk it?
Yep. One of them had custody of one of the children, but because he didn't want the other child to be alone, wouldn't have a brother or sister over there, he decided to take the child back and give it back to her.
No, that's just lazy. That's just lazy.
I found that very disgusting. I did. Absolutely disgusting. Yeah. So, I mean, that's what we're going to talk about today. I came across some really cool music. I thought about uploading it over here, but I need to make sure that it'll clear that copyright bullshit with YouTube, because that will drive you insane dealing with it day after day.
Oh yeah.
So, you know, before I put it on here, I want to make sure it clears it. It's kind of weird though. Hang on just one second. Okay, just a second. I can't stand this. I gotta get it off of me. All right. I had to get that. I can't stand it. I was like, oh, rub that off there. Okay, much better. It's kind of weird. I'll give you a little bit of a little peeky of what kind of music it is. I'll only play just a few seconds of it, and you might be going, oh no, not that. But it's weird. It's different, but I kind of liked it, you know, because it's weird and it's different. So let me go see if I can find it. We'll play just a little bit of it right quick, and then we'll get on with our show. Oh, that's my husband. Wrong thing. Let me see if it's going to download. It's not going to download there. Okay. My iPad is full, so I can't really put anything else on it, which is kind of crazy, right? But let me see if it'll let me pull this up over here. If not, we'll just have to move on with our show, and that's fine.
Oh, I love the scarf.
Oh, thank you. It came off of a bag, some bag that I have.
Yeah, super cute.
That's cute. I want to wear that. Okay, we're gonna have to go
super cute.
It's hot today in Texas. Thank God.
Yeah,
you know, I hate cold, and so finally I put away the electric blanket and all that. I think we're over here, you know, warming the hell up. So let me turn this up for just a second. I'm gonna play this. You can tell me what you think, if you can even hear it. Can you hear this? Let me see. Oh, go away. Okay. I don't know if it's going to play or not. Go. Oh, can you hear it?
No, not really.
Okay, here, hang on. Can you hear it now?
No, it's really, really, really low. Excuse me.
I know it's a little weird, but kind of like, I was like, oh man, that's like this chanting music that I found on, I think it's Nordic. I think it might be Nordic is where it's coming from. I was like, that's kind of cool. I know a lot of people won't
Huh.
think it's cool, but I think it's kind of cool. But anyway, so that's
Yeah.
working on some kind of just some little, you can do like little clips of music. Can't use maybe 10 or 15 seconds of somebody's music. That's all that'll be allowed. So it'll be just a bunch of little clips of that. But anyway, let's get on over here to our appeal. I have all of that pulled up and ready to go, or I tried to anyway. So this particular case has had many different things happen in the appeals court, which is another thing that's kind of interesting about it. Okay. Ooh, did you hear what's happening in the Celeste case, the D for David or whatever his name is in Celeste?
No, I haven't.
They had filed some documents in the state of Texas to make his family come to California and testify in a grand jury hearing, in a grand jury trial about before they file formal charges against him. They filed, and the family filed some writs and stuff because they didn't want to be forced to go to California. So now that's been heard, and it's a big old mess. And it's very disturbing, and it's very unfair that they can't. That his family will not go to California and do what's right by Celeste. Her family
Yeah.
just answers right. We know he did. We know he's responsible for this in some way or the other. I don't know if you ever watched any of his videos, but I watched a video one time, and it was recent, before anybody realized that Celeste had been gone a long time. The person he called Celeste in this video that had this hood over, kind of a hood over it, was not the real Celeste. It was somebody else pretending to be Celeste. Celeste had been gone much longer than people realized. So
Right.
So let me tell you what I'm seeing over here. And this is what's weird about YouTube. And it happened yesterday too. That's why I think it might be my internet. I keep seeing this little blue circle that's popping up every so often. Okay, and when that happens, it's changing the number of over here, the little I numbers. See the little watch number things. It changes when that little see it'll go in and out, in and out. So I think it's my internet. I'm gonna have to talk to my husband about this because I noticed it yesterday, and I thought, well, maybe it was YouTube, but no, I think it's the internet now because I'm on StreamYard. I mean, okay. Anyway, let's pull this up. So that's kind of interesting things about what's going on in that case. But this sick bitch over here, I'm gonna say it. I'm being ugly. I know I am, but it is sick. The way she's very flat. She's very what's the word I want to use? No emotion at all. Continuing around, I don't care for this. Okay, there. My iPad just said, oh, your connection's not private. And so what? I just want to pull up the little document that I already have and let's go with it. Okay. Oh, don't do this. It's over here on my, there it is. Look. I saved it yesterday, so I wouldn't have to go through all that today. Here we go. Now then, McDonald. Oh, my Lord. I quit using this iPad a long time ago because I knew it was really, really going to be full, of, okay, because it was just running out of everything.
Yeah.
Madison McDonald. Now, this is the brief overview. We're going to read the entire brief, but this is just the overview, just a little quick overview before we get to the actual brief itself. So, the Madison McDonald appeal brief in Texas. This document summarizes publicly available appellate information related to Madison McDonald versus the state of Texas, a capital murder case involving the deaths of 2 minor children. This overview is intended for content analysis, education, or media commentary purposes. Oh, let's see if it's not there, is it? No, damn. Okay, because I need to read my statement. After we read this, we'll read our statement. Case background. Madison McDonald was convicted in Texas of capital murder involving the deaths of 2 of her children in 2021. The prosecution alleged that asphyxiation as the cause of death. Following the trial, she received a life sentence without parole. Now, The appellate issues raised, and this is very interesting. The appeals oral arguments, we played that yesterday. It's very, very interesting. It's short, but it's interesting. The appeals focused heavily on the use of state psychiatric experts connected to her insanity defense. The defense argued that the experts' testimony violated constitutional protections, including the Fourth, Fifth, and Sixth Amendment rights. And after hearing that yesterday, I do agree. Because one of the experts says, well, whether I talk to her or not, I've already made up my mind. You can't do that. That's just like a juror saying, well, before I've heard any testimony, I've already made up my mind. She's guilty. It's the same thing, right? So I thought it was disgusting. And the state knew this. I mean, clearly, even though she basically pled guilty by reason of insanity, and it was just the trial was really about was she saying or not saying. And she was pretty sane. And so she gets the life sentence. Okay. So the defense counsel also argued that the objections were properly preserved at trial and that the appellate court should consider whether admission of this testimony affected the fairness of the proceedings. I'm not going to tell you what the appellate court's decision was yet because we're going to actually read this. And I'm not going to tell you what the current status is, but the content creation angles, it breaks down the insanity defense in Texas, how expert testimony can affect appeal outcomes, constitutional challenges in criminal appeals, and potential implications for future and similar cases. It really does need to be looked at. It's very important. I mean, I don't even understand the prosecutor allowing this to happen, to be honest with you. They knew. It's sick. It's absolutely sick. Okay, what's this? Okay. That's powerful weapons. That was my UFO one. There we go. Let's get off of here. So, that's Word. Go to my files. Let's go. Recents. Okay. Come on. I downloaded this yesterday on here. Oh boy. For a reason. Okay, here. Continue anyway. All right, here we go. This is the dissenting appeal from the 204th Judicial District Court in Dallas County, Texas. All right. And this is for Madison McDonald. Are we ready to go? This is how many pages is this one? I think I want to say 49 pages. It's pretty long, but this is where we get to, I'm sorry, it's only 20 pages, thank gosh. Okay. We are deeply troubled with the process by which Dr. Compton came to conduct the insanity evaluation and the district attorney's office handling of the matter. Yeah, and this is, the funny thing about it is when you watch the oral arguments, one of the justices was so fed up with this whole proceeding, he's just looking at him like, when are you going to shut up? It was very fascinating. If you have not had a chance to go watch it, please go watch part 1 from yesterday because you'll be like, good Lord, the looks on their face and the things they said to the defense attorney and the prosecuting attorneys. When they were talking to the prosecuting attorney, they were just upset. But what they were upset about to the defense attorney was because it seems like he had a hard time making the point. So finally, one of them says, are you trying to say da-da-da? And he goes, basically, yes. And so it was just the whole thing was funny. This is not a funny matter, but it was a funny oral argument. Okay, so I share the panel's concern about the process by which the state's insanity evaluation was conducted and believe that the process directly violated Madison McDonald's Fifth Amendment rights when Dr. Christy Compton was chosen by the state to testify. The record indicates the trial court shared that concern. Where I part from the panel and perhaps from the trial court is that, in my belief, McDonald's objections to the state's insanity expert was brought timely. My belief is her objections were properly preserved and presented to this court, and my belief that harm, both of constitutional and of actual nature, was demonstrated. For these reasons, I respectfully dissent from the court's refusal to rehear this appeal in bank. Okay, now I'm going to pull this up, and just because we're going to describe we're going to read the meaning of these words to help people understand a little faster, a little easier, because these words come up again in these appeals. They always do. It's typical legal language that, a layperson is not going to understand. So we're just going to help everybody out by go ahead and saying it. So when he says, in bank. Okay. The definition of the word in bank is it refers to a legal procedure where all judges in an appellate court, rather than a standard 3-judge panel, hear or rehear a case together, usually is reserved for exceptionally important or complex cases. This full court review is used to ensure consideration in cases. So it means all, not just a panel of 3. Okay. The other word that they use a lot is the word dissent. Okay. So let's pull up the word dissent. Okay. Go. Let's go, baby. Let's go. Okay. It's thinking. It should not have to think. It should just go right to it. See, I think this internet is slow. It refers to an opinion written by one of, or okay. It refers to an opinion written by one or more judges who disagree with the majority decision in case. While the majority opinion creates the binding law, a dissenting opinion has no immediate legal authority. It just serves as a formal record of disagreement and an appeal to future courts or legislatures. So, if this one judge says dissents, they don't agree with the rest of them. Okay, so, ready? Let's move on. Did you say something? I'm sorry, Sprinkler.
No, I didn't say anything.
Okay. So he goes. My belief that McDonald's objection to the state's insanity expert was brought timely. We've already read that. All right. And for these reasons, I respectfully dissent from the court's refusal to rehear this appeal in bank. Nothing I write here suggests ill intent on the part of any participant involved in this litigation to this point. The district attorney's office made a mistake, and it is not obvious that the prosecutor who tried the case was aware of the mistake until the trial commenced. The trial court presented Sophie's choice and made the middle of the trial the decision in which seemed least problematic. Sophie's choice, okay. Because this trial was not televised, we were not able to go watch the trial. So we could only see little pieces of the news story or what we can find as far as reading whatever news story there was about it. We can't watch the trial itself. So that made it a little bit hard as well. He goes, the trial court presented the Sophie's choice and made, in the middle of the trial, the decision which seemed least problematic. The panel, of which my predecessor was a member, gave considerable thought to the problem and simply resolved the issues differently than I may have or remember, okay, as a member of the panel. Let me reread that. Gave considerable thought to the problem and simply resolved the issues differently than I may have were I a member of this original panel. I believe these issues should be considered by the full court before the case moves to the Court of Criminal Appeals, which certainly will be the next stop, because that is not the court's choice. I write separately to record my observations from the record presented us. Okay, so this is just one of the judges. Number 1, the background. This case concerns the April 5th, 2021 deaths of A.H. and L.M., both minors, by asphyxiation at the hands of their mother, Madison McDonald, on June the 14th, 2021. McDonald was indicted for capital murder of A.H. and subsequently pled not guilty by reason of insanity. Psychological examinations of the request of both parties occurred while McDonald was in the Dallas County Jail. McDonald was ultimately deemed competent to stand trial. She was tried, found guilty, and sentenced to life imprisonment without the possibility of parole. McDonald raised a number of issues on appeal. The panel rejected her appeal on all counts and affirmed that the judgment of convictions. I write to address only McDonald's 6th point of error, just related to the retention of and testimony by Dr. Compton and the panel's disposition of same. Critical dates. Okay, this is called number 2. Critical dates relating to Dr. Compton. And reviewing the record, it is unclear where, when, or how Dr. Compton was initially retained by the district attorney's office. The first recorded interaction was on June the 11th, 2021, when the district attorney's office sent an email to Dr. Compton and or her office stating, "It's my understanding that Dr. Compton has been retained by my office to do an assessment of Madison McDonald for insanity, etc." Dr. Compton's office responded with a request to be added to the Associated TechShare account where she could access discovery materials related to McDonald. So what she was doing is she went ahead and she got the materials about the case and she read through it all, and then she formed her opinion without ever talking to Miss McDonald. Now, she eventually goes and sees Miss McDonald, and she goes through all the standard procedures for competency and sanity, does the standardized testing, which they had a big to do about the testing as well. But she openly admitted that she had already made her decision before she ever went to visit with Miss McDonald. So, 3 days later, McDonald was indicted for capital murder of A.H. On July 23, 2021, Dr. Compton's office emailed the district attorney's office about the need for retention letters to gain access to the McDonald at the Dallas County Jail, where she would wait until after the defense experts see McDonald. So the defense experts gets their chance first, and then the prosecutor goes. Okay. Now, here's the thing. If I was an attorney, I would have sat and watched. You're allowed to be there. The attorney's allowed to be present. I would have watched, or I would have had it recorded. This was not recorded, which is a problem. I think every one of these should be recorded. Although, I mean, it comes back to, I believe there's some kind of, I don't want to say this wrong because I'm not sure, but I often wonder, is it not recorded and shown in court because of a HIPAA thing, or is it because it simply does not? All it is to find out if they're competent. So why I don't know. They showed Letitia Stouches in court, and from there I just thought, well, every one of them should have been shown in court. So, but I'm just saying they don't always show them in court. Just to let y'all know that.
Right.
But I think they should. So then he goes. The prosecutor responded, "I'll work on figuring that out and get back to you." On July 26th, the prosecutor emailed Dr. Compton's office stating, "So I think it would be best to wait for now. Since the case is newly indicted, we haven't finished ordering the records and that we'd like for you to review. I'll reach out when it looks like we're further along." Dr. Compton's office responds with a reminder about the need for retention letters. On July 30th, 2021, McDonald filed a motion with an accompanying affidavit from Dr. Lisa Clayton suggesting McDonald was incompetent to stand trial. So that was Dr. Lisa Clayton was the doctor for the Fitz side. On August the 21st, McDonald's counsel spoke with the prosecutor and agreed to Dr. Compton performing a competency evaluation. Then on August the 4th, 2021, the district attorney's office sent the retention letter to the Dallas County Sheriff's Department stating, "Christy Compton, PhD, has been retained by the state to conduct a psychological evaluation of Madison McDonald." This letter was forwarded by the district attorney's office to Dr. Compton by email. Additionally, this email explained the ADA did talk to the defense and explained their report was expired and you could see her on Thursday and get us a new evaluation, and the defense counsel was fine with that. So why was something expired? Okay, that's question. I have questions about that. Don't let me forget to think about it. On August the 10th, 2021, Dr. Compton examined McDonald to determine her competency. During this examination, Dr. Compton asked McDonald specific questions about the offense. McDonald's counsel was not present. Dr. Compton did not advise McDonald that she had the right to remain silent. From the record, it's unclear when this report from the examination was sent to the district attorney's office and McDonald's counsel. So in other words, it's a question about the Miranda rights. So, okay. Then on October the 25th, 2001, Dr. Compton asked the prosecutor when or if they wanted her to proceed with an insanity evaluation. So she's going to do both parts instead of one person doing one and somebody else doing the other. She's going to go ahead and do both parts. Okay. That's normal, I guess. It can be strange. Okay. So that happens. The next thing happens on November the 9th. Dr. Compton's office emailed this prosecutor asking if there is a hearing to contest her competency findings that she made be known in advance so she can meet with her again prior to the hearing to make sure she's still competent and doing well on her meds. On November the 11th, 2021, the prosecutor emailed Dr. Compton stating, "The defense is asking for another competency evaluation. I would presume from Dr. Clayton before proceedings. They tell me Dr. Clayton should meet with the defendant next week." Dr. Compton thanked them for the update. On April the 4th, 2022, the district attorney's office emailed Dr. Compton stating that Dr. Clayton determined McDonald was insane at the time of the offense, but her report was not finished. Okay, so she's deemed insane at the time of the offense. On June the 14th, 2022, McDonald gave written notice of her intent to raise an insanity defense to trial. On June 22nd, 2022, the state filed a motion to appoint Dr. Compton as a distinguished expert. I'm sorry, not distinguished, as a disinterested expert for the purpose of the court-ordered insanity examination pursuant to Article 46C 101A. On June the 23rd, 2022, the court appointed Dr. Compton to examine McDonald and prepare a written report. She's supposed to be a disinterested party. Remember the words disinterested, because this comes into play in the oral arguments. On July the 25th, 2022, the prosecutor emailed Dr. Compton for an update on the status of her report. On July 26, 2022, Dr. Compton responded that she would be going to see McDonald for a sanity evaluation on July 27th. Her findings would be emailed, but the full report would not be ready until August the 1st. The prosecutor forwarded this email to McDonald's counsel. On July 27, 2022, Dr. Compton emailed the district attorney's office to state McDonald will not meet legal criteria for the not guilty by reason of insanity based on McDonald's confessions to a detective, and that her opinion will not change after seeing McDonald. Okay, and this makes it kind of questionable here. And we're going to talk about this for a second. Just because we know that even in mental illnesses, some of them, just because they were able to confess about what they did does not mean that they were not insane at the time they did it, or that they were not competent, or it does not mean that. There a lot of people have been I don't want to say crazy, but have been very mentally ill and very mentally disturbed, and they knew what they did. They knew they did it, right? But that does not mean, I disagree with her right here. I'm not a doctor, I don't claim to be, but I disagree with part of this. And but I guess because I know what happened in the oral arguments, had I not watched that part, I might think differently. We'll just leave it at that. Okay. I don't mean to confuse y'all, but anyway. So she goes, then on August the 3rd, 2022, Dr. Compton performed an insanity evaluation. On August the 12th, Dr. Compton emailed her full report to the district attorney's office, stating a caveat that she wanted to schedule a time to discuss additional information not needed for the insanity opinion. It's unclear when or if this was forwarded to McDonald's counsel. On April the 5th, 2023, the district attorney's office sent an email to Dr. Compton and McDonald counsel recapping a phone conversation Dr. Compton and the prosecutor had. The email requested that Dr. Compton bring to the court all notes or drafts she produced in process of completing her insanity evaluation. The email continued, "You were retained to complete the competency evaluation of this defendant only, but were not retained to complete the insanity evaluation of this defendant." Okay, so she was only retained for one part, but she did both. Now that's questionable as well. Dr. Compton was requested to forward all information about invoices, her retention by the state, and handwritten notes to all parties. McDonald's counsel did not receive a responsive email. On April 10th, 2023, a pretrial hearing was held. April 11th, 2023, the voir dire commenced. On April the 12th, the trial began. On April the 15th, McDonald filed a motion to suppress and disqualify Dr. Compton. On April 17th, here's the hearing on the motion to suppress. On April 17th, 2023, McDonald's counsel presented the arguments that McDonald's Fifth Amendment rights were violated and Dr. Compton was a state agent, not a disinterested expert. I agree. Following the testimony from Dr. Compton, largely focused on the timeline above and from Dr. Clayton, McDonald's counsel summarized her request to the trial court with the following. "We're asking you to disqualify Dr. Compton for two reasons. Number one, that she violated Madison's Fifth Amendment rights. And number two, that she was not a disinterested expert. She never was. There was no way she could have become a disinterested expert, and it never happened. And that's what 46C 101 requires. We're asking you to disqualify her." The response by the state was focused on the 46C problem, stating, "So really, we're dealing we had a court order appointing Compton under 46C, and their position is she shouldn't have been appointed under 46C. The remedy, the easiest remedy is, okay, she hasn't submitted a bill. We will retain Dr. Compton for the purpose of insanity. We will pay her. She will be the state's expert, and we can rescind the court's order under 46C. So they didn't properly go about it, but they're going to go ahead and pay her for her work anyway, and that way it covers it, is what they're saying. This sounds so Mickey Mouse. Wow. The state continued arguing that this is literally a paper error, noting that McDonald's counsels were the ones that brought this to our attention, which is the only reason we went searching for the emails that we found. This discussion then moved to what is the crux of the author's opinion. Dr. Compton's discussion with McDonald during the competency exam about the facts of the underlying offense. Earlier during the testimonial phase of the hearing, Dr. Clayton testified that in her forensic training, she was trained to not ask about the specific facts of the offense and the individual's commission of the offense, because that would be a violation of the person's Fifth Amendment rights. But she discussed them, and she knew what they were. She'd already seen the records, and she did discuss it without Mirandaizing, without Ms. McDonald having been given her rights prior to her discussing the incident. Okay. She testified that she never does that. It is not necessary to form an opinion about competency. She testified it is not the accepted practice in forensic psychiatry to ask about specifics of the offense in a competency exam. The court then asked Dr. Clayton, in your opinion, does this violate the Fifth Amendment rights for psychiatrists to be interviewing someone about competency, to delve deeper into the facts of the case and ask about the nature of the offense? Dr. Clayton answered in the affirmative, adding a caveat, without explaining and Mirandaizing them, and know that there's an attorney is aware of it, in a follow-up question by the court. Okay, so she's saying basically yes, she knew that this was improper. Dr. Clayton was cross-examined by counsel for the state. She testified that she did not inquire about the facts of the offense during the first competency exam, stating that she did not because Ms. McDonald was incompetent and delusional, and she would not have had her Fifth Amendment rights. After the second competency exam showed McDonald was competent, Dr. Clayton advised McDonald she would be moving to a sanity evaluation, and this was a whole different ballgame. And I kind of, Mirandaized her at that. I would be getting information from her that I would be sharing with the attorneys, and then her attorneys could, at their discretion, maybe submit a report. And then at her attorney's discretion, I might testify on the reason that the other side, you or the prosecutor, might be using these things that she's telling me against her. Okay, see, that is never the position of the doctor. This doctor should not be, she should not ever be used again. She's went outside of the scope of what she was hired to do. This is wrong. Okay. Returning to the discussion with counsel, portion of this is a suppression hearing. After the state's paper error, the state argued that Dr. Compton represented the court and that it is her usual practice to inquire about the facts of the offense in order to accurately determine whether the defendant was competent. The prosecutor noted that Dr. Compton purposely did not include any of the defendant's statements in her report to protect her Fifth Amendment rights. The prosecutor concluded, so there's nothing that says she can't do that. And he noted that Chapter 46B authorizes the examining professional to consider anything else that she can deem as relevant. The trial court clearly understood the dual problem presented. Number one, Dr. Compton had obtained information protected by Fifth Amendment during her competency examination. And number two, Dr. Compton was not a disinterested expert for the purpose of Section 46C, which at the time of her appointment. Yet she was called to testify that McDonald did not suffer from insanity at the time of the offense, and Dr. Compton had in fact obtained information that from McDonald about the facts of the offense without Fifth Amendment protection. I know it's a little hard to understand, it just goes back and forth, but basically it's like you overstepped your boundaries. You did. The argument then turned into the potential remedies. The parties could not agree on a remedy, so the trial court announced her ruling. Okay, the defense's motion is denied. Oh, shit. Okay. The court then granted McDonald a running objection to everything Dr. Compton says and testifies for all the reasons we've been talking about this morning. Now, here's the actual argument. Let me take a drink. It's kind of interesting, isn't it? They all know that this took place. They all know what the rules are. Damn. I mean, these kind of mistakes right here is this is what gets things overturned right here. This stuff. I check every day about Letitia Stouches. I want to know as soon as that opinion comes out, I'm jumping on it. We're talking about it as soon as. Nothing yet though. Okay, so here's the argument. By her issue number 6, McDonald argued through multiple subpoints that the trial court erred by permitting the state to use rebuttal evidence that was illegally obtained by the state's expert in forming her opinion about McDonald's resilience on the insanity defense. Much of the briefing on this point focused on the Article 46B appointment of Dr. Compton for competency purposes and her Article C appointment for disinterested expert on insanity. The author believes these arguments have merit, but I am focused on the Fifth Amendment aspect. Dr. Compton clearly was an agent of the state for the Fifth Amendment purposes. She clearly saw herself as retained by the state as early as July the 11th. Per my reading of the records, McDonald presented her Fifth Amendment arguments timely. The trial court understood the arguments but overruled the objection when neither party would agree to the proposed cure. Discharging the jury and starting all over again, McDonald preserved her era. She presented the argument on appeal. Harm is presumed for its constitutional reasons, and harm is demonstrated. Without Dr. Compton's testimony, the state had no evidence to rebut McDonald's evidence that she was insane at the time of the offense. My reasonings laid out below. And this is what he says. Preservation and presenting of errors. A party may claim error in the omission of evidence only if the error affects the substantial right of the party, and the party timely objects or moves to strike and states the specific ground, unless it was apparent from the context. I'm not going to read all the citings because this is when it gets really long. What the court hears are parties' objections outside the presence of the jury and rules that the evidence is admissible. A party need not renew an objection to preserve a claim for an appeal. Okay. McDonald explicitly presented to the trial court with objection that Dr. Compton's insanity testimony should be excluded because Dr. Compton obtained evidence forming basis. Dr. Compton obtained evidence forming a basis that the testimony in violation of the Fifth Amendment. The trial court considered that objection in a lengthy middle of the trial hearing, and the trial court expressly overruled the objection. The more difficult question is whether the claimant error was properly presented to the court. My read on the briefing is that the claimed error was presented. Admittedly, most of McDonald's brief on issue 6 focused on the statutory problems with Dr. Compton's appointment. However, McDonald clearly argued her Fifth Amendment objection to the admission of Dr. Compton's testimony. She quoted Estelle versus Smith. They talked about that yesterday in the oral arguments. Very interesting. If you missed it, please go back and watch it, or maybe we'll rewatch it this afternoon. Let me see. Let's see if we have enough time. On issues related to the privilege against self-incrimination, and she distinguished Perry versus State. On the question of the witness being an agent for the state for the Fifth Amendment purposes. 3 full paragraphs of the brief were focused on Article 38.21 of the Texas Code of Criminal Procedures, which is the remedy for the Fifth Amendment violation, namely exclusion of the evidence. In fact, McDonald's cites to Estelle was explicitly in constitutional arguments. McDonald quoted Chief Justice Berger's opinion for the proposition that the Fifth Amendment privilege is fulfilled only when a criminal defendant is guaranteed the right to remain silent unless he chooses to speak in the unfettered exercise of his own will and to suffer no penalty for such silence. But she didn't get that opportunity because this information was related to the court, and so they did use it against her. That's the whole question. Yes, they used it against her and found that she was sane and sent her to prison for the rest of her life with no parole. For this reason, the author believes the constitutional error was both preserved and properly presented at the court, and for the reasons explained below, Estelle is so factually on point that it may require a reversal. Sadly, it may. I agree. Timelines of the objections. An element of error preservation is the timelessness of the objection. A proper objection is one that has specific and timely, and it starts citing Martinez, blah, blah, blah. To be timely, the objection should be, if possible, be made before the evidence is actually admitted. Then it goes, the panel opinion and much of the argument in the trial court focused on the lapse of 10 days between McDonald being advised that Dr. Compton might testify for the state on the insanity issue and McDonald filing her motion to suppress. I believe the argument is misplaced. Number one, unquestionably, McDonald's Fifth Amendment objection was made before Dr. Compton testified. In my opinion, the fact alone ends the inquiry. And number two, a motion to suppress was not required. McDonald could have simply objected at that time to Dr. Compton, and she was presented with the first question about her opinion regarding McDonald's sanity. And it starts, the sightings over here. The defense must have objected to the evidence, if possible, before it was actually admitted. If it was not possible, the defense must have objected as soon as the objectionable nature of the evidence became apparent and must have moved to strike the evidence. So what it should have happened in the middle of this court is if they're going along, he should have stood up and said, I object. And they should have had a bench up to the bench to talk about it. And then the judge should have said, y'all are going to strike that. You do not hear it. Do not use this evidence to when you're in the jury room. That's what should have happened, but that's not what happened here. On June 14, 2022, McDonald provided notice of her intent to raise an insanity defensive trial. 9 days later, Dr. Compton was appointed to conduct the insanity exam. On August the 3rd, 2022, Dr. Compton performed the insanity exam. On August the 12th, Dr. Compton provided her report to the district attorney along with the cryptic comment that she wanted to schedule time to discuss additional information not needed for the insanity opinion. Then nothing on this front occurred for almost 8 full months until 6 days before voir dire, when the state copied McDonald's counsel on an email possibly suggesting that Dr. Compton will provide rebuttal testimony of the insanity issue. When I look at the timeline and the delays effectuated by the state in deciding whether Dr. Compton would testify for the state, I simply cannot stretch logic to conclude that McDonald is the one failing to timely raise the issues. On the record, I see through the stage of briefings, McDonald timely made her objections to Dr. Compton's testimony. And here's the actual harm that happened from all of the events that we just discussed. Assuming McDonald had properly preserved her objections on the Fifth Amendment grounds and the trial court abused its discretion in denying her motion to suppress, this error cannot be deemed harmless. And it goes, see Chapman versus Blah. An error in admitting plainly relevant evidence which possibly influenced the jury adversely to a litigant cannot be conceived as harmless. The question is whether there is a reasonable possibility that the evidence compiled might have contributed to the conviction. And I believe it absolutely does, because here's what happens. When you're in a courtroom and, the jury's sitting over there listening to all this information, the jury seem to perk up when they hear expert testimony or when they hear testimony from a peace officer. They perk up. They pay attention because to the jury, these people are trusted. They're the experts. They know, right? That's how it's perceived. So this is very harmful. So we'll keep going here. An error, and it goes, there's a reasonable possibility that the evidence compiled might have contributed to the conviction. In Scott versus State, the Court of Criminal Appeals expressed that the emphasis of harm analysis pursuant to Rule 44.2 is not whether the jury verdict was supported by the evidence. Instead, the question is the likelihood that the constitutional error was actually a contributing factor in the jury's deliberations in arriving the verdict. And it gives a bunch of sightings there. And then it goes, we are not concerned here with whether there was sufficient evidence on which the petitioner could have been convicted without the evidence compiled. Because McDonald pled not guilty by reason of insanity, the critical evidence presented in trial would center on whether she was sane at the time of the offense. Multiple witnesses were presented and questioned about McDonald's actions and thought process before, during, and after the offense. Of these, only 2 were specifically trained in were trained in mental illness diagnosis and symptoms applying to the conjunction with legal status. Forensic psychiatrist Dr. Clayton and forensic psychologist Dr. Compton. Had Dr. Compton's testimony been excluded, the jury would be left with only testimony of Dr. Clayton that McDonald met the legal criteria for insanity defense on April the 5th. Dr. Clayton's testimony included the following assertions of McDonald's sanity at the time of the offense. And she, based on what she was saying to the police officers, if you listen to parts of her interrogation, it is, yeah, okay. It's, yeah, she sounds like she's insane. But remember, Letitia Stouts tried to sound insane as well. So think about that when we're talking about this. McDonald totally believed she was only temporarily sending her daughters to heaven, and she exposed a child pornography conspiracy. God would send them back down to her. What? Okay. An auditory hallucination. Mark told her the only way to save her children from being caught in a sex ring was to send them to heaven. McDonald believed it would not be wrong or thought of as wrong by individuals who were not part of the conspiracy. So, good people, that she was not wrong and good people would know she was not wrong. McDonald's was manic, psychotic, and had not slept in days. The case of Miss McDonald is the most pre-offense evidence of her having a severe mental illness prior to committing these offenses. I mean, it was evident to everybody. Comparatively, the following testimony of Dr. Compton would not have been heard by the jury and would not have been in the final word from the expert witnesses before their deliberations. Miss McDonald did not meet the criteria for insanity. Miss McDonald retained the ability to understand the wrongfulness. Miss McDonald may have believed her delusions after the offense and engaged in revisionist history. In other words, well, it's going to be okay. I'm going to get them back. It wasn't really real. Okay. Dr. Compton's opinion of McDonald was not insane, was cemented after her review of her police interview and McDonald's statements as close to the time of the offense as she could get. So before she ever spoke to her, she just watched the interview and said, oh, yeah. Okay, see, she's saying, look at her. She's telling you what happened here. McDonald's thought processes were organized. She was able to complete linear, goal-directed, coherent sentences, and she probably wasn't having any auditory or visual hallucinations during this police interview. Accordingly, the erroneous admissions of Dr. Compton's unconstitutionally obtained testimony possibly contributed to McDonald's conviction and is thus reversible. If the appellate record in a criminal case reveals constitutional errors that is subject to harmless error review, the Court of Appeals must reverse a judgment of convictions and/or punishments unless the court determines beyond a reasonable doubt that the error did not contribute to the conviction or the punishment. And here's his closing thoughts. For 45 years ago, the Supreme Court of the United States was faced with a competency sanity scenario quite similar to this before the court today, arising out of a Dallas County Estelle Supra. While Estelle reached the Supreme Court on federal habeas, Chief Justice Berger's opinion is instructive, and of the opinion of this author mandates reversal and remand for a new trial without the state relying on the testimony of Dr. Compton. In other words, they cannot bring her back to testify. Ernest Smith was indicted for murder. The trial court ordered psychiatric examination of Smith to determine competency. The psychiatrist conducted a 90-minute examination of Smith without advising him that he had a right to remain silent. The psychiatrist found Smith competent to stand trial. Smith was tried and convicted of capital murder. During the penalty phase, the psychiatrist was called to testify. Among other things, the psychiatrist testified Smith was a sociopath with no regard for other human beings' life and with no remorse for what he had done. The psychiatrist's testimony was based on information derived from the 90-minute competency examination, and Smith was then sentenced to death. The Supreme Court answered the affirmative to questions whether the psychiatrist's testimony violated Smith's Fifth Amendment privileges against compelled self-incrimination because Smith was not advised before the pretrial psychiatrist examination that he had a right to remain silent and that any statement he made could be used against him at a sentencing proceeding. The court concluded the Fifth Amendment privilege, therefore, is directly involved here because the state used evidence against Smith in the substance of his disclosures during the pretrial psychiatric examination. They absolutely did the same thing to her. I can see where they're going. Estelle involved testimony offered by the state in the penalty phase, whereas this court today is confronted with testimony offered in the guilt or innocence phase. That is a difference without distinction. In fact, in Estelle, the state argued that Smith was not entitled to protection of the Fifth Amendment because the psychiatrist's testimony was used only to determine the punishment after conviction, not to establish his guilt. The argument was soundly rejected by the Supreme Court. The availability of the Fifth Amendment privilege does not turn upon the type of proceeding in which the protection is invoked, but upon the nature of the statement or admissions and the exposures within which invites. So, whether intentionally or accidentally, McDonald's Fifth Amendment rights were violated when Dr. Compton testified for the state that McDonald was not insane at the time of the offense, basing at least some of that opinion on information obtained from McDonald during her initial competency examination. For that reason, I believe the court should rehear this case in bank. I recognize that no one wants to retry this case, albeit with different states' experts on the issue of McDonald's state of mind at the time of the offense. I note that this very option offered by the trial court upon consideration of the motion to suppress an offer rejected by McDonald. A retrial is the likely result where the court could agree with me, because a retrial is the only solution that protects McDonald's Fifth Amendment rights. I respectfully dissent from the court's denial of the motion for rehearing on this. And this is from Justice Mike G. Lee. Okay, and Jay Lewis joins the dissenting opinions. So what they're asking for is, well, everybody else should go back and look at it now. Hey there, how you doing? Let me see. Aunt Judy, no, it's not Aunt Judy. I'm sorry. Who are you? Papa Mavis. Well, thank you for coming in. We appreciate you. Thank you for coming in. We always like to see new people. No, I'm not Aunt Judy. I'm just somebody who likes to read these appeals and look at these cases. So this is what happened there. Now, there's a lot more of this because that was just those two. Then they actually had their oral arguments in front of the. Hang on a minute. They had their oral arguments, and we watched that yesterday. Please, if you have not had a chance to go watch it, go watch it. It's very interesting. Now, let's get to what really happened, and is she getting a new trial? Because that's really the meat of. This just leads us up to whether that's going to happen or not. Do I think this lady was sane at the time that she did this? No, I don't believe she was sane at the time. I don't believe she was sane at the time that she did this. However, when she was in trial, I showed some little. I showed some of the news stories that had pictures of her while she was in the trial. And at one point, she looks back at the people in the audience, and the look that she gave, I saw nothing. Okay, I saw a sociopath right there. She had those dead, dark, black shark eyes that we talk about all the time. Just nothing. There was nothing in that mind, nothing in those eyes, nothing. So I think that scared. She actually scared me. The way she looked scared me. So just think about that. Now let's go find out what happened at the end of the situation. So she had her oral arguments. Okay, I don't want to save to the drive. I just want to read it. Okay, here we go. Come on. Okay, now let's go back down over here. Okay. So in the parties, we had the appellant. It was Madison McDonald, and the attorney was Michael Mola, and the state of Texas, it was Jacqueline O'Connor Lambert. So, I'll go ahead and pull this back up. Here's the brief filed, a motion to dismiss. Okay, submitted. Let me go back down here to granted. Here we go. Come on, open. A motion for extension of time. So they filed several different motions to extend time for answers on these things, which you don't see that happen very often, but it did happen. So the Court of Criminal Appeals, let's get back over here and find out what exactly happened. Okay. Madison McDonald. It's right here. Hang on. Let's see, was it granted? Okay. So pull this up over here. Because this just happened. So there was the submission for this Court of Criminal Appeals. This was November the 19th, 2025. They had the oral arguments, and then the next part that happened was May of 23. I got to pull it up by dates over here. More search results. Come on now. Oh boy. It was the oral arguments, and then Texas mom, blah blah blah. Just a second, guys. Okay, come on. I have it right. Come on now. I have it here. I got it from Justin, but go ahead and start talking while I find it. Okay.
in cases like this, I always have to compare to Andrea Yates,
Uh-huh.
where she was really mentally ill and she was convicted and put in a mental institution. And
Mm-hmm.
then say Lindsay Clancy, the recent couple
Oh
years
yeah,
ago,
her.
where she killed her kids with the exercise bands.
Uh-huh.
Who's the
We're
nurse?
talking about her too. Yeah. Yeah.
Yeah, I feel like she was definitely insane at the time. I feel like she was definitely mentally struggling. So any case like this, I always tend to compare to other cases. And in this one, it's really I'm 50-50. I don't know. I don't really have I feel like yes, she was, but then when you look at her behavior afterward, how she just walked into the police station and was like, I did it. Like she knew the ramifications of what she did. She knew her kids were dead. There was, to me, some kind of sanity in when she went into the police station. So
Okay.
it's, you know what I'm saying? It's just, I don't know about this one.
So
Because I know
here's
that
where we are.
there's certain
Okay.
criteria they have to meet in Texas to consider it mental illness, and it's questionable if she met that criteria. I mean, they have to know at the time of the murder that the ramifications of their actions. I don't remember all the things. There's like three or four different things that they have to meet that insanity defense. And
Well,
depending
I
on which
mean,
side you look at, the one side makes it look like yeah she did, and the other side makes it look like yeah she didn't.
she even if they are insane at the time that they did it, or that they even if they find that they're not competent to stand trial, they will try to uh, they will keep working with them until they become competent. See what I'm saying? So really,
Right,
there is no.
right,
It's kind of like there's no real. I don't think there's really an insane, a guilty but insane, really, because
right.
if they spend all this time to get them to where they are competent, I mean, do they just sit in the mental hospital for a long time? I mean, I
Right.
don't know. I mean, it's kind of a let's see.
What's that threshold? What's that
Yeah.
criteria to consider them now sane?
So, as of late February 2026, Madison McDonald has not yet been granted a new trial, though her case is currently at a critical stage with the state's highest criminal court. So, it is in the Court of Criminal Appeals. They have had their oral arguments, and now we're just waiting for the courts their um, to issue their orders or grant or deny the petition. Is where we're at. So,
Mm-hmm.
active appeals. The TCCA granted a petition for discretionary review for this case, whether McDonald's constitute. Okay, so that's what we looked at yesterday. They had oral arguments. The oral arguments were heard in November 2025, and the pending decision as of February has not yet released a final ruling of whether to overturn the conviction and order a new trial. The core legal issues. The push for new trial stems from a dissent written by an appeals court justice who argued that the state's use of insanity experts violated McDonald's Fifth Amendment rights. And I really do agree, based on all the things that we've seen on this, I do agree. Because you cannot, that is, to me, it is exactly the same, as I explained a while ago. To me, it's exactly the same as, well, the jury decided they were guilty before they ever sat there and listened to the trial. So
Yeah.
it's the same thing. And I mean, she really did not have the right. She was not even hired. She was not hired to do the insanity. She was hired to do the competency. But she took it upon herself to get so further involved to get more information. And since she had already done it, the state says, "Oh well, we'll just remedy this by paying her for it, and she could just be our witness anyway." I just think this person should never be called as an expert again. I think that
Right.
I think
No.
she's
Agree.
really
100%.
made a mess of this case. I don't think that should happen. It's kind of, but this woman, she's. Hang on a second. Let's pull something up for a second. I know we watched this yesterday, but just a little reminder of what we're looking at here, as far as Madison McDonald goes. But now Lindsay Clancy. Now we're also doing Lindsay Clancy. We've done part of it, and we're keeping up with the trial. and as soon, I hope that this case is televised. Now, Texas does not do as many televised uh, um, jury trials as other states do. They just don't do it as often. I hope I hope that her case is televised, because if it is televised, we're going to sit right here on my channel over here and we're going to watch it all day long to keep up with it. To me, there's something about Lindsay Clancy that I find so incredibly strange. I don't think that her and Madison are on the same level of sanity or competency. There's something completely different about them. Really, there is. The thing with Lindsay Clancy is she is a nurse. She's very familiar with postpartum. She's a labor and delivery nurse. She's very familiar with this. She sees labor. She sees these patients every single day. Help, being in the labor delivery rooms. She sees the depressed mom. She sees all of this. I think that trying to claim postpartum psychosis, I just don't. I don't know if that's what happened to her or not. It's not up to me to know, but I don't see it as that. I think something else happened, but I don't think it's postpartum.
Just you don't think so?
Not for Lindsay Clancy. No, I think that there's something wrong, but I don't think it was postpartum. She was taking a lot of different drugs, and she did not really take them as they were prescribed. It kind of goes back to that black box warning from our other case when he was taking the Accutane and took double the dose and then killed his friends.
Right.
So, right, I think the drugs had something to do with what she did. Whereas with Madison induced psychosis. Yeah, that's what I think. But with Madison, it's completely something different. She's. Just go back over here and see if I can find her interrogation. And we watched a little bit of this yesterday, but we're going to watch some more of it right now because it is so very interesting. Now, this is well, I don't want to show that part. Hang on just a second. This is when the mental health experts testify. It's only like 2 minutes, but because the trial was not, this is all we have is like just 2 minutes of it. And this is going to be from CBS Texas. So hang on just a second, and we'll share our screen. Hang on a second. Let me share my screen so we can see this together. There we go. Okay. And this is from the mental health. This is when the mental health person is testifying. So, CBS. There we go. All right. There you go.
Capital murder after admitting to killing her 2 daughters is now in the hands of the jury. Our Ken Molestina says that today's testimony focused on the opinions of mental health experts.
As planned, testimony in Madison McDonald's trial got off to a late start on Tuesday, and it brought out dueling mental health experts who offered opposing opinions on McDonald's mental status at the time of her alleged crime. The defense's expert witness was forensic psychiatrist Dr. Lisa Clayton, who described her examination of McDonald.
She was very focused on her paranoid delusions about conspiracy by family, including her ex-husband, her mother, Irving police, about her children being, her 2 daughters being sexually molested and participating in child porn.
The defense is trying to prove McDonald is not guilty by way of insanity, and that she was off from medicine and having a mental health episode when she drugged and smothered her daughters, Lillian and Archer, in 2021.
She was doing it based upon her paranoid delusional system that the only way she could save them from being physically taken and sold into sex slavery ultimately was to make them deceased.
Do you agree that at the time?
Now, if you remember yesterday, there was another thing that I showed y'all where she's had runabouts with CPS, etc. Because at one point she's seen with a this cardboard thing in it was in the in the window. She had this thing in the window, and it said, did you fall out? Where you at, girl?
I lost sound, so I had to go out and come back in.
She had this thing. Let me get rid of this one over here. Okay. Okay, are you there? Okay. She had this thing in the window that said, help, call the FBI. Woman and 2 children are in trouble. Or at risk or something like that. So that was something else. So she had been having bouts of things happening mentally for a while. This was not just all of a sudden she got up one day and decided, oh, today I'm going
Right.
to claim this. In other words, she's had some mental illness going on for a while. And
Right.
when I heard the father testify that he had custody of one of these children, but because we'll just replay his excuse. I'll let you see his excuse. It shocked me. I was like, you got to be kidding me. Let's watch this. Here we go.
Time of the conduct charge, Madison, as a result of her severe mental disease or defect, did not know her conduct was wrong.
Yes, that's my opinion. I agree with that.
The prosecution's mental health expert is arguing that opinion, saying she didn't find that to be true during her assessment of McDonald.
My opinion was that she was mentally ill, and I believe that the mental illness undergirded the offense. I don't think there's any doubt about that. But it did not render her to the point that she did not understand that her conduct was wrong or illegal.
I'm Ken Molestina, CBS News, Texas.
I mean, that's very interesting. I mean,
Dawson and Callan were face down on the floor.
Yeah, that's our other case that we're
The
taking
trial
care
of an Irving mother.
So let me go up here. And this is where this is the interview. Let's watch this little 3 minutes on this interview that she did with the cops so you can gain your own opinions.
Irving police.
This is from
The prosecution rested its case in the capital murder trial for a mother who confessed to Irving police that she killed her 2 young daughters.
Much of that final testimony focused on the police interview conducted the day after Madison McDonald killed her daughters in April of 2021. In it, she continues making claims she killed them to protect them from abuse. Her lawyer argues she was having a severe mental health episode and did not know what she was doing. Fox 4 Stephen Dial, live tonight with more on today's testimony. Stephen.
Today we learned how Madison McDonald sedated her children. She told investigators that she put pills in their yogurt. Now today, her defense team says that she was off of her mental health medication, and they presented a line of false claims that she repeatedly made to the Irving Police Department.
I felt like I did what I had to do to protect my kids. And it's not what I wanted to do. I'm not okay. I don't think it's right. I think I do deserve to be arrested.
Friday, prosecutors wrapped up their case in the capital murder trial for Madison McDonald, the Irving mother who confessed in 2021 to killing her 1.5-year-old daughter Lillian and her 6-year-old daughter Archer. Much of Friday's testimony focused on the police interview conducted one day after the murders.
I gave them some pills, and Archer went to sleep, and Lillian didn't. She just kept going. So I thought that was odd, because she's a baby, essentially, so it should have, affected her heavier. It's just so hard to say, calling for a while.
McDonald told police she killed them to, quote, protect them from abuse. She told police that she gave the girls Xanax and other pills in their yogurt. She says she smothered her youngest child around.
Look at her. Just watch. Okay, I'm going to read my fair use disclosure right quick because I forgot to do it earlier.
Yeah, get that done.
So, for fair use disclaimers, these videos contains copyrighted material such as news footage, court records, and photographs, the use of which has not always been specifically authorized by the copyright owner. We are making such material available under the fair use doctrine for the purposes such as criticism, commentary, news reporting, and education. This constitutes a fair use of such copyrighted material as provided for in Section 107 of the U.S. copyright laws. The material is used in transformative manner to provide legal analysis and context to this Madison McDonald's case. All rights and credit go directly to its rightful owners. No copyright infringement is intended. So there's our copyright fair use disclaimer about anything that has to do with this particular case or the materials that we use about this case or really any other true crime case. So there she is standing there just waiting for some police officers to come out there and get her. Now, one of the things about this, what you're going to see is in her hand, she has the actual damn blankets that she used to smother these children with. She brought that into the police station with them. Now, when you talk about it that way, it's as if she does know exactly what she did. So, I mean, it is very questionable if she's mentally ill or she's just a damn sociopath. She's one of the two of them. She probably both. Here we go. Let's keep watching.
1:30 in the afternoon on April 12,
So horrible.
2021, and killed her oldest daughter about 7 hours later.
I have tears because I'm sad for this. I missed it already. But I'm not sad for saving this. How long have you been planning that? It's not that I have been planning it, it's that I knew or you wanted to protect them. How long have you thought about saving them? Well, I've been fighting to protect and save them for like a year.
When the prosecution rested its case.
Did you catch that? Oh, for about a year. She's been playing this for about a year. So, is this premeditated? Is it? See why it's so hard and it's so questionable about her? Is it? I mean, I don't know. To me, she's a sociopath. Honestly, okay, I'm going to say it right now. To me, she's just a sociopath. Period. There is no cure for that. We all know that. I mean,
right?
Sociopaths are. She's done all. I mean, this is not the only thing she's done, though. That's the thing about it. When they went back and looked at some other things, good Lord. No, sorry, guys.
The defense called up several Irving police officers. They gave testimony about 3 incidents where a woman fitting the same description as McDonald made false claims that her children were in danger.
We got a call that they received a note from a lady that drove through the drive-through and passed a note that said, "Call the FBI. There's a woman and 2 children in danger."
Her lawyer is trying to prove that she's not guilty by reason of insanity. They've argued that she suffered from bipolar disorder and schizophrenia, and that she was off her medications. Throughout the trial, they've worked to establish a pattern that she was not in her right mind.
Because this thing that she believed was true and had been happening for over a year was causing her daughters to be in harm.
Correct.
But it wasn't true.
It was not.
And she believed it.
She did.
Week 2 of the trial will resume on.
Now, with that information, Sprinkle, what do you think?
Yeah, I don't. This is just such a hard one for me. It really is. I don't know which side I fall on. I really don't.
Right.
I want to feel like no, she wasn't mentally ill. I don't know. That's just where I'm going. Just because why would she wait 7 hours in between killing both children? If you're in a manic state and you're out of it or whatever words you want to use, you're gonna just do whatever you're gonna do at that moment. You're not gonna be like, let me kill this one and then I'll kill that one later.
Heartbreaking murder.
That to me doesn't go.
Okay, yeah. I'm gonna share this one too. We're gonna watch this one for a little bit. It's like CBS Texas. Let me get full credit, CBS Texas. We'll watch this one and hear a little bit more. I really wish this would have been televised. I would love to have seen this trial. You know, it's interesting, but it's heartbreaking at the same time. You see, let me put this up here.
I mean, to a certain extent, to kill, I don't know. I kind of feel like to a certain extent, to kill anyone, you have to be mentally ill because no sane person is going to murder someone, whether it be however they do it. But it's the level of mentally ill that comes into play. Does that make sense?
Yeah, it does. And the one thing we do know about sociopaths, because we've discussed this many times, they understand that they are different from the rest of us. They understand that they have to mimic how other people act or react into the world every day, because that is how they learn to appear normal, so that people don't realize they're actually sociopaths.
Right. They want to blend in. Yeah, they want to blend in. Yeah.
It's only the people who live with them who get to know them really, really well to realize, oh my God, something's wrong. Let's watch this one real quick.
Breaking murder investigation playing out now in Irving. Police say a woman has confessed to killing her 2 young daughters. Our Brooke Rogers live at Irving Police Headquarters right now with more details. Brooke.
Steve, police say it was around 10 o'clock last night. She very calmly walked through these doors of the Irving Police Department, picked up the phone, and told the dispatchers that she had killed her 2 young children. She told police that she had smothered 1-year-old Lillian Mae McDonald and 6-year-old Archer Hammond. Irving officers came out to the lobby and to talk to her, and then sent police to the Anthem Apartments in the 700 block of Cowboys Parkway. There, police, along with assistance from Irving Fire, found the bodies of the 2 little girls. The mother, Madison McDonald, was arrested and charged with 2 counts of capital murder of a person under 10 years of age. We do know that the girls have different fathers, neither of whom live with them at the apartment. Irving police say.
Let me ask you something, Sprinkle. Who does she look like to you?
Hold on, I walked away. Oh, to who Madison looks like?
Yeah, who does Madison look like?
She kind of has a look of Letitia in those eyes, but I don't know. Or Lori with red hair,
or Katie Proudfoot.
Oh
Sebastian's
yes,
she looks
yes,
like
she
mother.
does. Yes,
Which sadly today,
yes. If you look at the whole face, I was just looking in the eyes. Yes, you're absolutely right. You're absolutely right.
That
It
would
would
be
be
interesting, wouldn't
interesting.
it?
Put a side by side up of them and see what they look like.
Ooh, I wonder if I bet I could do. Let's finish listening to that. Let me see if I can find that. We'll see.
While
Not
the
that it has anything
investigation
to do
is
with
still
it.
in its early stages, they're trying to determine a motive.
In a situation like this, this is obviously a horrific incident where 2 children were murdered. We may not ever know the why, right? Because there's not going to be a definition or a reason that would ever justify the murder of 2 small children.
And McDonald is currently at the Irving jail with no bond. She's expected to be transferred to the Dallas County Jail sometime either today or tomorrow. Live in Irving, Brooke Rogers, CBS 11 News.
Heartbreak.
All right, let me get back up there.
The father of one
Here's
of
the
the
father.
Irving
This is
girls
the father's
prosecuted.
testimony. Here we go. This is
The father of one of the Irving girls prosecutors say was killed by their mother told a jury about the moment he learned of his daughter's death. Madison McDonald is charged with killing her 2 daughters, a 1-year-old and a 6-year-old. She walked into the police department in 2021 to confess. Lawyers say she was dealing with several mental health issues.
See those blankets? See that right there? Those blankets? She actually smothered those babies with their own blankets. That's right there in her hand. Each one of them had their own blankets. And so she used the appropriate blanket on, whichever child it was, and she brought it to the police station with her. She brought the evidence in with her.
Wow.
Yeah. That to me is a sane person. I don't know. I think she's a sociopath. Yeah, here we go.
Timothy Hammond, the father of McDonald's oldest daughter, today said he knew when they first met that McDonald was dealing with mental health issues.
I knew she was bipolar, kind of from the get-go. Disbelief.
Mental health issues doesn't make you a murderer, though.
No, it doesn't. You're right, it doesn't.
It doesn't. We all suffer from mental health issues to a certain degree, but that doesn't mean that we're going to kill anybody.
I agree with you on that too. I do. But what he says, some of the things he says, it's come to me. I'm like,
but if you were concerned, why would you leave your kid there? Regardless if you were afraid of them not having their other sibling around. If you were that concerned, you'd take both kids. You would take them both away.
Right. I have questions about that right there. There you go. Let it play out.
I don't know.
He doesn't know.
It didn't seem real.
Yeah, because you're a loser and you left your kid there with somebody that you weren't sure about.
Which is really hard to listen to.
This falls on you.
McDonald's attorneys say at the time of the murders, she was not aware what she was doing at the time was wrong. Prosecutors say she was well aware and is charged with 2 counts of capital murder. Testimony will continue in the morning.
See, I believe she was. Hang on.
I've seen different cases over the years. I mean, this goes back many, many years, where they've had a person who literally was insane at the time of their murder. When they come back to sanity, they are an emotional mess, knowing what they have done. They break down, they're hysterical, they cry. They realize what they did in their state, and they're devastated by that once they're back to being leveled out. She doesn't show any of that. Any of that.
No, she doesn't. It's quite shocking, really. I mean, I don't know how you can. She knew that she crushed them. She knew exactly what she did. She told them exactly what she did. She drove herself over there to tell them what she did. She knew she was going to get arrested. I mean, to me, that is very different than I don't know why I'm here.
She was trying to cover her ass. Is what she was trying to do.
That's very different
She
than
was
sitting
just trying to cover her ass. Yeah, she would be devastated.
Hang on.
She would be devastated knowing what she did to her children in a mental health crisis. Let's use those words. Knowing that she did that to her children, she would be hysterical. I would be hysterical. Normal people would be hysterical. That's not her reaction. Her reaction is
Let's watch
simply
Lindsay
somebody
Clancy
who's
for a second. Okay.
Yeah.
Watch her. This is Boston 25. Whoop. Yeah. Here we go. Let me share the screen. We'll watch Lindsay Clancy for a minute because she's another questionable situation because it doesn't make any sense, right? Now, this was just an emergency hearing they had last month on Lindsay Clancy. Here we go. And this is going to be Boston 25 News. Full credit, Boston 25 News. All right. Oops, I got to turn it on.
Of killing her 3 young children to appear in court via Zoom. This is new video of Lindsay Clancy during a hearing in the last 30 minutes. She was supposed to appear in court for the first time in person tomorrow. Clancy was left paralyzed following a suicide attempt after she allegedly killed her 3 young children. Boston 25's Bob Ward is with me now. So, Bob, her defense team requested that she not appear in person for mental health issues. And if she does ever go to court, they do want some special accommodations.
Yes, because they say that Lindsay Clancy has some very serious needs that must be met for physical needs and her mental health needs. And still, this decision still leaves unanswered a key issue. How will Lindsay Clancy get to court for her own trial? That's set to begin this summer. Now, that's usually the job of sheriffs, but this case is unique with its own set of complex issues.
Ms. Clancy will be haved into the Plymouth location.
Until now, this is the only way we've seen Lindsay Clancy, over video streams from Tewksbury Hospital, where she's been held since the murders of her 3 young children 3 years ago. But in court right now, a battle over her transportation. Clancy's lawyer wants her driven to court in an ambulance.
I don't understand. I really don't. And I will never understand. Why should she get special treatment just because she's in a damn wheelchair and she's paralyzed? Okay.
Yeah.
You have paralyzed people in damn prison. But so what they end up doing to get her to come to the court hearing, she ends up with 2 deputies and 2 nurses being driven in a damn ambulance like she's somebody special. She's not hooked up to an IV. She's not getting, I mean, she's eating and drinking food. I don't understand why she's being given special treatment.
She's just paralyzed. That's it.
Right. That's right. We'll keep watching, but this kind of irritates me really bad.
And not in a sheriff department's wheelchair van. Boston defense attorney Peter Ellikin tells me, given Clancy's physical and mental health needs, he's not surprised.
It is not an unreasonable request that she be taken in an ambulance every day because, first of all, she's not a flight risk. She's not going to escape. And that's a crucial thing.
Lindsay Clancy is charged with first-degree murder for the strangulation deaths of her children. Clancy jumped out of a second-floor window of her Duxbury home in an apparent suicide attempt. She's now a paraplegic. Clancy's lawyers plan to argue that over-medication and postpartum mental illness were behind the murders.
Certainly, this defendant, Lindsay Clancy, is going to need more support than a typical defendant who is brought in a sheriff's van in handcuffs and shackles.
Boston defense attorney Elise Hershon tells me the issue over Clancy's transportation may set the tone for her trial.
She is a sympathetic defendant in this. She's a victim also of mental health issues. The question is this premeditated murder or a result of mental health or defect, which is the legal term for it?
You know, one of the things about this is, and because when I did this live show the other day, we kind of talked about her. Well, I did 2 live shows on her so far, but we talked about her plotting are telling her husband to go pick up food from this one location. She knew exactly how many minutes that she had for him to go do this round trip on the things she needed, you know. And so to me, that's almost premeditation, just like giving little kids medicine in their yogurt was premeditation. Okay? To me. But we also have a health professional saying, well, just because they were able to do that does not mean that they were not mentally ill. Well, was her jumping out of the window and all of a sudden, oh shit, look what I've done. I need to jump out the window now to take myself out. Or was that part of the plan to begin with? That's another thing we don't know. We don't know, you know? It's, there's a lot to this case. There's a whole lot to it. And I just don't believe that this is the first time. I believe that there's other things that happened before, but nobody paid attention to it. See, that's what I think. Here we go. We'll keep listening.
That's going to be the huge issue at trial.
So at one point, Lindsay Clancy's trial was scheduled to begin next month, but now it's set to start in July. And just how will Lindsay Clancy be transported to court? Well, Kerry, that remains unclear.
And Bob, every time we report on this story, the only word that comes to my mind is tragedy. Tragedy for this entire family.
Yeah, this issue, this case is going.
Yeah, it is a tragedy. It is a big issue. But, you know, there are a lot of people who in prison who are in wheelchairs. So I just don't understand what they think they're going to do here. Let me see if there's something else we want to look at on her right quick. Hang on. But watch her appearance. Okay, this is when she shows up to court this happened last Friday. I believe it was last Friday. And this is going to be Long Crime. Okay, Fred Long Crime. Right. Just make that better for you. You can actually see. Okay, wait. I just saw her maneuvering that wheelchair all by herself. She did not need somebody to push her, move around. I don't understand why she's getting special treatment. She can use her hands to roll herself up to the desk. She just did it. What the world is going on here? Sprinkle, what is this? Shit. It's not fair.
Yeah. No, it's not right. There's no, I mean, and they're not big because she has mental health issues, quote unquote. That has nothing to do with it.
No.
No.
No, I mean, if she could not maneuver herself at all, if she could not do anything with her hands, if she was complete, I think it's only from the waist down and she has problems. That's what I believe it is, paraplegic.
Right.
Then I could maybe see some special treatment, but nah, hell nah. She don't need no special treatment. No. This is wrong. Oh my. I did not notice this the other day. I did not see that. Damn.
Well, they're just trying to paint the sympathetic picture. They're trying to set up the narrative to make her a sympathetic person to have sympathy for her.
I don't like how he's got his hand on her chair. Look at this. Watch how he's treating her. Watch his hand right there.
Like treating her like she's the victim. She's not the victim.
Right.
Her children.
She's the victim. Right. Oh God, I did not notice this. I'm glad we're rewatching this today. Here we go.
Court, all right.
Oh, okay. All right.
This honorable court now session be seated, please.
Wow.
Good afternoon, Your Honor. Good afternoon, all. This is called the criminal court list for Plymouth County at Plymouth on 2/20/2026. First case is according to call. Is number 2 on our list, 2383 CR 198, the case of Commonwealth versus Lindsay Clancy. This case is called for motions for the record of the defendant's present before the bar. Counsel for the
This
record,
person not
call.
standing up.
Good afternoon, Your Honor. Jennifer Sprague for the Commonwealth.
Oh, there we
Good
go.
afternoon.
And Shannon Buckingham also for the Commonwealth.
Anybody? Good afternoon.
Good afternoon, Judge Kevin Briggs, on behalf of Mr. Clancy.
Mr. Reddington, good afternoon. Ms. Clancy, good afternoon. All right, so this is a matter, for a number of reasons here today, I think. But first, I just kind of want to know, we talked about the evaluation. And I know there was a motion that was just recently filed. And by recently, I mean just the last day or so. So I'm not sure we're going to address those motions that were filed.
Now, I believe that her husband and her are divorced, but he was supporting her. I've heard something about that he moved back to New York. I'm not sure about all that, and I'm going to look this up right quick. Lindsay Clancy. Let's see what it's saying about her husband, because I thought I saw him in the courtroom the other day through this whole hearing crying. He was crying, and I mean, I understand his kids are gone. But and I understand that maybe he wants to, I don't know, wants to support her, but he's never going to have a life with her. Okay,
No.
so as of February 2026, Lindsay Clancy and Patrick Clancy are still legally married. While Patrick Clancy has
wow.
moved to New York City and the couple no longer live together, he has not filed for divorce. In multiple interviews, including a significant feature with The New Yorker, he continues to refer to Lindsay as his wife and has publicly expressed forgiveness, stating that he was married to someone who got sick, not a monster. Okay, all right. But let me tell you something else that happened in this case. Both he and so Patrick and Lindsay have both filed separate lawsuits against the doctors and drug makers over the wrongful deaths of the children. Help me make that make sense.
Yeah, well, they're saying that she was over medicated, is what they're saying.
Right. Yeah. Okay, Dylan Dozer. Well, I'm sorry that your daughter has a mustache, but please, we don't want trolls in here. This is a serious conversation. So thank you for stopping by. I'll let you stay, but we just can't have trolls in our chat, okay? But thank you for stopping by. We appreciate you. Thank you so much. Yeah, something doesn't make sense about it. I don't know, because my sister, you're gone. Sorry, you're gone. We're not going to have
Yeah,
that.
bye. Yeah, bye.
Bye. Goodbye. Yeah. Please do not come in here as a troll. It's not going to happen. We don't allow it. This is a serious conversation, but I would like to make it. It just doesn't make sense. How is she filing a wrongful death suit against the drug? She is a nurse. She is a labor and delivery nurse. She knew what she was taking. She knew the DSM-5. She knew all of that. But it's kind of to me, I think it's almost like she's grasping at money. She's just grasping.
Oh, yeah.
There's no way she's walking out of that courtroom without doing any prison time. That's not going to happen.
Yeah, a wrongful death here. Let me pull it up.
Yeah, go ahead.
Yeah. You might want to turn that music down just a little bit. It's kind of loud.
Do you hear music? Because I don't hear any.
Yeah, it's a Little Red O
isn't
song
that
is
something?
playing in the background. Yeah.
I did not know it. There. I didn't even know
There
it.
we go.
There you go.
Yeah.
All right, good.
Says the husband of Massachusetts woman who's accused of killing their 3 children at the family's home in 2023 has filed a wrongful death lawsuit against the providers who treated Lindsay Clancy in the months leading up to the tragedy. Patrick Clancy's civil suit was filed in Norfolk Superior Court Wednesday. This goes back to January. Against psychiatrist Jennifer Tuff, certified nurse practitioner Rebecca Jolata, Astor Mental Health, and South Shore Health System. The suit alleges that treatment by these providers exaggerated Lindsay Clancy's mental health struggles and resulted in her allegedly killing the couple's 3 children. Indeed, the bevy of diverse and powerful medications they misprescribed, coupled with their abject failure to appropriately monitor Lindsay, resulted in Lindsay's mental health deteriorating to the point of suicidal ideation and requiring inpatient care. Ultimately, defendants' negligent treatment of Lindsay, including their complete failure to recognize and address the radical erosion of her mental health, resulted in tragedy, namely allegations that Lindsay took the lives of her children, the lawsuit reads. If defendants had not acted negligently and rather had provided adequate care, it is more than likely than not Patrick and Lindsay's children would still be alive. Prosecutors have said Lindsay Clancy killed her 3 children by strangling them with exercise bands after sending Patrick Clancy to get takeout food from a specific restaurant, which was included as part of her plan. Following the attacks, officials alleged Lindsay cut her wrists and neck before jumping from a second-story window in an attempt to end her own life. She has been confined to a wheelchair and is paralyzed from the sternum down as a result, according to her attorney.
Huh. Did you find anything where she had previous problems with mental health?
No, I haven't dug that far.
Take a look and see if you find anything about her having previous. Now, I did not realize that she had cut her own wrist and attempted to cut her own throat before she jumped out the window.
I didn't know that.
Thought she
I
just
didn't
jumped the
either.
window, so that's new information
I
right
thought
there.
she just jumped.
Right. Huh. So while you look that up, we're going to talk about something else, though, real quick. Now, y'all know the other day we were doing our live to give away our handbag. And, of course, YouTube had to be an asshole about it and decide that we had a copyright issue, which we really don't, but okay. We're going to redo that because they shut it down. I did my argument with them and all that, but now I can't get it back up and part of it was actually missing because they removed the part of it that they decided was the copyright thing. But anyway, so we're going to redo that. But I want to show you the things we're going to do. Now, I showed this the other day, but I haven't had a chance. I showed it the other day, but I did not put it back in its bag. So here's its original bag right here. So you're going to have a choice of either this beautiful little pink bag right here. It's either going to be this one. Okay, let me get this off of the screen right quick so we can talk about this. Let me unshare that screen. Stop sharing. Okay, there we go. So it's either going to be this beautiful pink bag here, right here. It has its own little.
Oh, I love that.
This own little
love
pouch right here that comes with it. Okay. These
I
are
love
all brand
pink. That's
new, still in original packaging because I'm a collector. Then
That's
I
my
also
favorite
have,
color.
your
Love
favorite.
it.
Then I also have this beautiful black
Yes.
one. Either way. Okay.
Oh,
So
love it.
here's the deal.
Oh, that's beautiful too.
If we have 500 people, hey Cinderella, so good to see you, girl. How you doing? Listen, thank you.
Cinderella.
Love it. If we have 500 people in our chat, you have to stay the whole 2 hours because our shows run about 2 hours. At the end of the show, about 10 minutes before it's over, we will do numbers, and whoever has the right number, we'll ship you you get a choice. You can have the pink one or the black one, either one. We'll send you the bag. If we have 200 people in the chat, if we only have 200 people in the chat, I still have something I'm going to give away. It's so cute. Now, you hear me talk about spray ground a lot also. I love little spray ground bags. This is the cutest little spray ground bag right here. And it unzips. Here's the little, it's a little pouch thing. But it fits on your wrist. It fits on your little wrist. And it has a little thing
that's
for
cute.
your food. Right.
Yeah.
So what fits in here is actually your ID, your credit cards, and money. In case you're going somewhere where you don't want to have to carry a purse, you can just clip this onto yourself or put it on your wrist like this, and just walk around with a little hand purse. So if we have 200 people, we'll give this away. Okay. And if we have less than 200 people, I'm going to give choices of some of my other toys. I have a lot of toys. I collect these little pink dogs. These are little Victoria's Secret dogs that I collect. I have a bunch of these too in many different colors, so you'll have a choice of this. So no matter how many people are actually in our chat, we're going to end up giving away something. How about that?
Cute.
So that's what we're going to do. I also have a bunch of these. I mean, there's toys all over this room over here. This is one of my favorite toys. So while you look for that, I was just going to show some toys. This is one of my favorite toys. He's my big Labubu right here. He's cute. I'm not giving him away. I love him. His little eyes move. He's just cute. But anyway, just some of the things I collect, which it's like I never grew up. I'm still just a kid. Anyway, that's what we're going to do. Now, we're probably going to do our giveaway. I'm going to say like the week of March the 10th. We need to pick a day that myself and Sprinkle can be together because it's our show that we're going to give it away on. I don't know what the topic is going to be yet, but it'll be a topic that people can join and enjoy talking about, something that y'all want to talk about, not just these cases, but, something interesting, something fun. But that's what's up, and that's what we're going to do about our show that was messed up, thrown out, and, gone. I can't get it back. It's gone. So anyway, that's just our remake of our giveaway. So there you go. Has she had mental health problems before?
I've just found one. I'm looking up another one.
Okay. Good.
Let me look up.
I had to get my big pencil out to correct everybody. I wish this had red ink, but it's just a red pencil. It's just plain. It's just a plain pencil. It's just a big ass pencil. Oh God. So while she looks at that, we'll just talk about something else. Now today was also the 2-year anniversary of Sebastian Wayne Drake Rogers, who's been missing for 2 years. I know they were having a get together in Hendersonville, Tennessee. I watched some of it earlier today. I'm glad a bunch of people showed up to support Seth and his endeavor to get the FBI to take over this case to help find Sebastian Wayne Drake Rogers. I really never thought that in 2 years we would still be here. I really thought he would have been found already by now. This is hard, and it's sad. And I put on waterproof mascara today so I would not cry, because that his case and Devlin's case are both very, very precious to me. I did not keep up with much on Summer, but the other 2 cases I have. Now, on my Devlin Tate case, I have a lot of information that I received from my FOIA request that I paid for, or my sponsor paid for, because we do have a sponsor on this channel, and it's worldwaves.com. I got the information back, and the information that I received back, I've chose not to show. I'm not going to show it, because I will never, ever do anything to embarrass a victim. Okay, I would never do that. I'm not going to do that. So that information is going to be left exactly where it is. We're not going to discuss it. It's over. I'm not showing that. Okay. That I just want to explain about that, because I know a lot of y'all knew that we had done the FOIA to get the information, and that is the reason why it's not coming out, because of what it is, of what I was provided. No, I will never do that. So that's the end of that. Now, I know that Devlin is still missing. I know that there's if you really want to know about Devlin Tate's case, you need to go over and watch Lady Freedom's Raw Narratives, because she has a lot of the information on that case, and she talks about that case and Sebastian's case most of the time. There's another situation that we talk about a lot that I wanted to talk about, which is the Gypsy Rose Blanchard case. Now, as you know, there's a channel called Hurricane Hunter 2020, and she's worked really, really hard to try to get Gypsy Rose Blanchard taken off of social media. Now, I know some people disagree, some people agree, and it's okay if we don't all agree, it's fine. But as far as I'm concerned, Gypsy Rose Blanchard should not be on social media, because she used social media to get somebody to do the dirty deed for her, to plan a murder. That's why I don't think she needs to be on here. And so Hurricane Hunter ended up having to get a new channel started because of YouTube. Constantly, every time she would put something, she could never get that channel monetized, because they kept saying she was reusing content. So she just opened up a new channel. So I'm going to get her new channel out, and we're going to, I'm going to advertise it for her. We're going to drop her channel name. There's some other channels that I wanted to talk about too, and that is Into the Weeds. Now, Into the Weeds has everything you want to know about Gypsy Rose Blanchard. They have the FOIAs. It is free. You can go look at anything you want to. You can use their content. They want it out. They want people to talk about that case and the truth, because what we were presented when she went to prison, before she got out of prison, was all a lie. Every bit of it was a made-up lie. So let's pull up Hurricane Hunter so I can drop her channel for you. Just a second, guys. It's not Hurricane Hunter anymore. It's something weather. I thought I was going to know this for a fact, but let's see. Let me go to Hurricane Hunter and I'll pull it up. It's something weather. Okay, just a second, guys. I'll get it. While you look for the mental health stuff. Okay, here.
I found a timeline on Reddit as far as her the timeline for her stuff. May 26, 2022, Callan was born. She repeatedly told her husband how happy she was and how much she loved the new baby. She was enthusiastic and energetic. As June 23rd, she was 4 weeks postpartum and had no symptoms. July, they ran a 5K. September, they ran another 5K. August was 12 weeks after Callan's birth. P, who I'm assuming is the husband, goes back to work. Mid-August, per Lindsay's lawsuit, her mood suddenly switches from hypomania to anxiety and depression. She had debilitating anxiety, insomnia, and sleeping 3 hours per night. No motivation, could not exercise. In September, she begins to experience stress and anxiety, meets with a psychiatrist. She is diagnosed with chronic generalized anxiety disorder and chronic adjustment disorder with depressive mood and describes Zoloft. September, she met with Dr. Tuft again, and postnatal depression scale was 23. Zoloft was prescribed. The end of September, she went back to work. October, she says she hasn't taken her medicine yet, and she was on the verge of taking it, but wants to try therapy first. Mid-October, she started a dose of Zoloft and reportedly increased it as directed. October, she told the doctor she was feeling awful, having insomnia due to medication increase from 25 to 50 milligrams, did not want to eat, felt more depressed, was crying, and having mental fog. She was also terrified to start something new. Overnight, she developed racing thoughts and became paranoid of getting suicidal thoughts, something bad happening, doesn't want to be alone. Lindsay's lawsuit notably does not mention suicidal thoughts, but it does say that Dr. Tuft discontinued the Zoloft and provide Ativan and Benadryl for sleep. In October, she told the therapist she was hoping to return to work and was hopefully this would decrease her depressive symptoms. November, she made a Facebook group post. I couldn't get that out. I am not alone. Postpartum depression, anxiety, and rage, saying she was looking for advice on the meds for PPA and PPD. She tried Zoloft 1 week, and after increasing it to 50 milligrams, she had extreme nausea, depression worsened. She said Ativan is the only medication that worked for her because it's the perfect effect of decreasing her anxiety and making her feel happy again. Well, you have to give meds, psych meds, more than a week to get into your system. Minimum is 4 weeks. November, her insomnia had worsened and she's only sleeping 3 hours a night. November, she went to the ER, was given trazodone, but it was not effective. Let's see.
See, I don't think it talks about some benzo problem. Somewhere in there, it'll start talking about a benzo problem because I do remember reading this now. And I don't know if the benzo problem happened after she started getting these medicines because she said she couldn't sleep, or if she had the benzo problem prior to.
Here we go. Here it goes. It says November, after taking Remeron, she experienced dissociation, perceiving the world around her to be unreal, distorted, and distant. She could not determine what was real. She was forgetful, confused, and able to drive or be alone. In November 28th, she tells Nurse Paul she is struggling with sleep. Oh, I saw the benzo thing. What the heck?
Yeah.
Oh, she's struggling with sleep, disoriented, and not connected to her body. Petrified of becoming addicted to benzos, she felt like she was in a panic state. A week later, November 28th, she tells the nurse she's physically dependent on benzos to sleep. She completely overwhelmed, mind constantly running. She correctly considers the bipolar disorder and prescribes Seroquel. She reports that immediate passive SI after being prescribed Seroquel. I don't know what SI is. With the date listed.
I do.
Sleep insomnia? Suicide ideations.
Yeah, right.
Let's see. This is the end of November. She developed suicidal ideation and began experiencing what she described as intrusive thoughts, which were actually auditory hallucinations. The voice said, "I will not be the same. I want to die." Shortly thereafter, she tells her therapist that she had an addiction to Ativan, and that's why she couldn't sleep. She reports weight loss, poor appetite, panic attacks, numbness, reports suicide ideation for the first time, not to mention how she originally got the Ativan or who prescribed it. December, she told the nurse she had lost 15 pounds, no appetite, was experiencing panic attacks. December 4th, she was scared of hallucinations, so she called the suicide hotline. December 5th, she met virtually with a support clinician and was told she did not meet the criteria for input treatment because she didn't have a plan for suicide. Another on November 5th, intrusive thoughts of wanting to die. December 6th, she had an appointment with nurse. She's still only sleeping 3 hours a night, feeling overwhelmed, mind constantly running. Denies SI, but reports feeling something terrible might happen. She is prescribed Valium. December 9th, 3 days later, they speak that she was experiencing pain and SI. They say the nurse advised her to continue taking the medication. So this goes on all the way. I don't want to read every single one of them. So this goes on until, let's see, January 21st. They're friends. They go to dinner at a friend's house, and according to the friend told police, she seemed fairly normal, mostly quiet, was on her phone. The 23rd of January, this is the day before the murder. The psychiatrist notes she is a little more anxious. Her heart is racing. Mood is flat and anxious. She reports no motivation, feeling numb, and has forced herself up, notably in sight, as described as poor.
So she already had a benzo problem from at some point.
That started. Let's see. Let me go back to the beginning. That started May 26th of 2022, and the murders happened on January 24th. 2025.
The thing about benzos, though, if she's having withdrawal, she's not having psychosis. No, because if you're having withdrawals with benzos, you're going to have seizures. That's what happens. So I don't understand. You can't blame it on that.
It looks like she was picking and choosing the medication that she wanted to take,
rather
than taking what was prescribed to her. Yeah, she was not taking the medicines prescribed for her mental health. She was taking the benzos for the anxiety. She wasn't taking the Zoloft and the other things that would have helped her with her depression and everything. She chose not to take those.
You know, I think when you look at all the things they prescribed to her, I do believe they prescribed to her way too many things. I do believe that. But in the same sense, though,
it wasn't take all these, it was take this instead of a lot of times.
Right. Yeah. There's so many missing parts to this story that I think.
Yeah, she didn't give them adequate time to take to start taking effect. Let's see.
Let me show y'all a little bit of something from today while she was, hang on. I'm going to pull something up right quick, and we're going to watch this kind of in the background. This is what's going on today in the search for Sebastian Wayne Drake Rogers, okay? So just watch a little bit of this with us while we, I'm going to turn the sound off, but we're just going to listen. We're just going to watch for a minute about what's going on. Okay.
Yeah.
Whoop. Come on, quit that. Let me see if I can get myself back over here now. Okay, there we go. Now, I'm going to share my screen. We'll just watch a little bit about what's going on over there while we search for Sebastian Wayne Drake Rogers today, because today is the 2-year anniversary. So there you go. Okay. Cancel. StreamYard. Okay, so we'll just let that play in the background while you talk about the benzos and what happened. I don't think she did either. I think there's a lot of problems here.
Antidepressants generally take 4 to 8 weeks to reach their full effect, with some improvements in sleep or energy potentially appearing 2 weeks. While initially minor improvements may occur sooner, patience is required as the brain adjusts. If no improvement occurs 4 to 6, a doctor may adjust the dosage or medication. She literally took them for a week. And it says 4 to 8 weeks.
Long enough to do anything.
No, she didn't. But she liked the Ativan. She liked the benzos.
Everybody likes the happy pills. Benzos are happy pills.
Yeah.
Of course everybody likes them, right? You know.
Yeah, so she didn't even give them an opportunity.
I agree. All right. I can't stay on much longer. It's 4:20. We've been on almost 2 hours, but I just wanted to talk about, I know we went on a tangent, got off our original subject of Madison McDonald, but Lindsay and Madison McDonald are both horrible stories, horrible situations. But yeah, and we always do. But I'm going to turn this down for just a second. So this is for Sebastian Wayne Drake Rogers. Today makes 2 years. So If y'all
Justice.
go watch, listen. Okay, just go
Yeah.
watch and listen if you get a chance.
We appreciate it. And do you mind telling us who you are? Do you mind telling us who you are? Yes.
Anyway, all right.
Part
So
of the
this is over
Brooke
here on
family?
astrology for
Okay.
that's on astrology for mystics, but there's a lot of creators that are in Hendersonville, Tennessee today, all for Sebastian Wayne Drake Rogers, and the concern to get the FBI to take over this case from Sumner County, and that is what this is about. And I never thought that we'd be here 2 years later, but here we are. So we're gonna leave with that being shown right there. We're gonna come back. Are you off tomorrow? What are we doing tomorrow, girl?
I am off tomorrow.
All right. Oh, well, I'm traveling tomorrow for part of the day. So tomorrow night we'll be doing something. I don't know what it's going to be yet, but when I get to my son's house, we will go live then. So we really always want to thank everybody for coming in. We appreciate you spending your time with us. We understand there's so many other places you could be watching, and we appreciate you taking time to watch us. Now, if you have to catch us on replay crew, that's fine too. I always forget to ask, so please hit that thumbs up either on your way out or your way in. That's appreciated as well. That is how our work gets into the algorithm. Without that, I don't know if it makes it there or not. I have no idea. I'm not an expert on YouTube. But, so you all be careful out there. Take care of yourselves and take us on out, Sprinkle.
And hug your babies. Hug them
That's
tight.
right. That's right. Life is short, and your time with them is even shorter. We'll see y'all tomorrow sometime. Be careful out there. Thanks, guys. Bye.
All right. Bye, everybody.